Hello, and thank you for watching today. Today we're going to talk about one of the most common termination grounds. This, along with D&E, are the big ones that you'll almost always find in a department petition. And it's the service plans. That's how it's referred to, the service plan ground. Now, service plans are not mentioned in the statute, so I'm going to read over the statute and we're going to talk about it a little bit. So the O ground, as it's because it's under the paragraph O, states that the parent failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who has been in the permanent or temporary managing conservatorship of the Department of Family Protective Services for not less than 9 months as a result of the child's removal from the parent under Chapter 262 for the abuse or neglect of the child. That's a lot. And go through there, and you need to look at every element. And remember that the department has to prove every element. So, let me give you some quick information that has come up that is well established. First of all, it requires 100% compliance by the parent. Now, an affirmative defense has been added that if the parent fails to complete the services and the failure is none of their fault, it's completely other people's fault, not 0% their fault, then that's a defense. I haven't seen that happen yet. That's not how it works generally. If they haven't completed the services, it's usually because they haven't engaged as they should, or it turned out not to be necessary. And what I mean by that is 100% compliance, it sounds really strict, and it is. But remember a couple of things. All this gets you is a ground. Yes, it does make it easy for the department to prove a ground, and that's, you don't want to sweep away the grounds and just jump to the best interest. That's how they would like to do it. So you need to focus on this. But here's the other thing. If your client is 95% complied, is it going to be in the child's best interest if this is all they have? Probably not. Now, unless the 5% is something very, very important, like, it's the thing that brought the child into care and the parent refuses to address it. So even though it does require 100% compliance, it doesn't mean that failure to comply is automatically, again, going to lead to termination. But look at the elements. I mean, if your client's being held to completing them, make sure the state is held to proving all of the elements. The removal does not have to be from this parent. So if the child was removed from the other parent and you're representing the non-offending parent, then it doesn't matter. If the child was removed for abuse or neglect, it doesn't matter who the person was removed from. It could even be not the parent. But if there was abuse or neglect and the child had to be removed, then that meets that last part. Did the service plan specifically establish the actions necessary for a return? And this is one why you need to really be involved in the service plan. Look at my videos on service plan. You need to make sure that it is tailored, and you need to show that it is specifically established the actions necessary for the return. That if your client does these things, they should get the child back. And if it wasn't, first of all, you should be arguing to change it early on and throughout the case. And you need to argue that at trial. So the affirmative defense, what the language is, the parent was unable to comply with the specific provisions of the court order. The parent made a good faith effort to comply with the order, and the failure to comply with the order is not attributable to any fault of the parent. So it's not going to be, well, CPS didn't do their job either. The CPS often doesn't get their job done. And that's important, and it's something you want to argue about, but it doesn't mean that it gives them that affirmative defense. Has the child been in the department care for at least 9 months? If the department wants to go to trial sooner than that, they can't use this ground. Usually they're only going to want to do that in a severe case. And of course, you've got the argument whether they actually failed to comply. There's going to be some gray area that how it works is the service plan, once it's made up, it's going to be made in order of the court. And that's why they call it the service plan ground. So it's important to make sure that that service plan is designed correctly, that your client is following it. If they're not, or if something needs to be changed, get the service plan changed before you get to trial, so that they can't come back and say, this was an issue, this was in the orders, you didn't do it. If your client can't do it, if your client shouldn't have to do it, get the judge to take it out of there so that that won't be there. This is a common ground, and it's one that you need to follow throughout the case. Obviously, you can only encourage your client so much. You can only force them to do. Well, you can't really force them to do anything, but you need to stay on top of them and make sure that they are working their services, or at least that they know that they are working their services, and know that they are supposed to be working their services, and that if there's any issue, they need to talk to you about it so you can try to get it resolved. Thank you for watching today. Please hit the subscribe button, and I will see you next time.